Hey guys, I am here with Tom Banner of Paramount Title, and today we're going to talk about the title commitment and things to look out for.
Will, thanks very much for inviting me to talk about title commitments. I am a real estate attorney here in Santa Fe, and I have a title company called Paramount Title. We do business in Santa Fe and Rio counties, and I've had the pleasure of working with Will and his team at 7th Level Realty on several transactions. So I'm really happy to be here today to talk about title commitments.
Awesome.
Will, I put together a PowerPoint. If you don't object, I'll share the screen and give it a start. And if you have any comments or questions as we go through, just let me know, okay?
Sounds good. Let's get it rolling.
Okay, here we go. We're going to focus on how to read a title commitment here today. And I have put together a slideshow to go over a couple of the most important parts of a title commitment. But I wanted to start with a few basic terminology points. So a deed is different from title and is different from title insurance. So a deed is a piece of paper that is signed by a seller of property, and it says the seller is going to convey the property to the buyer, and it contains a legal description of the property being conveyed, and it's got a date. So a deed is that physical document that before COVID, we would have the seller sign at closing at a settlement table. And then we as a title company would carry down to the clerk's office and give to the clerk and say, hey, record this. Now, post-COVID, everything's electronically recorded. So the deed is oftentimes an electronic document.
Okay.
But that's a deed. Now, the word title is used to describe a bundle of rights that the owner of property has. And that bundle of rights include the right to possess, use, modify, or transfer any rights in the property. And title insurance then is a type of insurance that folks buy. It protects both buyers and sellers against claims of others in title to that land.
Okay. On the deed, when you're saying it can be electronic now with the COVID deal that's been happening, is that something? Can they sign that electronically, or do they still have to wet sign that and then it gets filed electronically?
So at least here in New Mexico, and I think 28 other states as of July 25th, 2022, there are statutes that provide for the electronic signing and notarization of documents. So we're sort of in a new arena here with these new statutes that basically allow a deed to consist of an electronic document that is never actually put on paper. It's really kind of an exciting time where technology is changing the way people do real estate transactions.
Okay. Have you seen a lot of title companies? Have they been embracing this new technology and new change, or are we still kind of seeing where it goes?
Well, I can tell you that Paramount Title, I've done closings with buyers and sellers all over the globe. I had a seller in Spain. I had a seller in Massachusetts, another in California, where I have used remote online notarizations to create a deed, an electronic deed, and the parties have then signed and I've notarized them. So that's awesome. Not unusual in my practice, but I can't really speak for some of the other title companies.
Sure.
But yeah, it's pretty exciting the way technology is allowing us to consummate these transactions where usually people have to gather around a conference room table. And now we can do it with essentially no one ever gathering around a conference room table. and everybody can be, at different points on the globe, and yet we still are able to close a transaction.
That's
on time.
fantastic.
It really is. So now that we've got those terms out of the way, what is a title commitment? Well, it is a promise by a title company to issue a policy of insurance on title to a certain piece of real property after closing. And you ask, well, who's really being protected? Well, the answer is, I say both the buyer and the seller, because the seller is giving a warranty deed to the buyer, and a warranty deed comes with warranties that the buyer has a full right and title to the property, and that they're giving that warranty to the buyer at closing. So in effect, the title insurance is going to protect the seller so that if there is a problem, the buyer doesn't have to go and sue the seller. They can make a claim under the title insurance policy.
All right.
Let's see here. Here in New Mexico, most purchase and sale agreements typically call for the seller to provide the buyer with a policy of owner title insurance after closing. That may differ in some jurisdictions or in some deals, but that's pretty much how I've seen it done. Will, how many times have you seen it done otherwise? I'm just curious.
Me personally, I have not.
You've not, okay.
Yeah.
All right. Moving on, there are two types of title insurance policies. One is an owner's policy and the other is a lender's policy. An owner's policy protects the owner, the buyer and the seller from claims that exist by virtue of, for example, an unpaid property tax lien or fraud in the chain of title, like a prior deed was fraudulently executed and recorded. Or here in New Mexico, since we're a community property state, there's always a chance that a spouse or an unknown heir may have a claim to title that they could come back years after the transaction is closed and say, hey, I own an interest in that property. So for an owner, the owner's policy of title insurance protects against those types of issues. If one of those issues arises, the owner can call up their title insurer and say, hey, these folks are saying that they own an interest in the property. You've insured me on this title. You take care of it.
Right. Okay. And
The
that's where the title company steps in.
Yeah. The other policies I said is a lender's policy. It protects a lender against those same sorts of claims. And of course, the lender doesn't want anybody else to be able to say that their collateral under the mortgage is no good. So
yeah, they want to be in first and second position, right?
Absolutely. Absolutely.
Got it.
So those are the two basic types of policies. And here is a typical page 1 of a title commitment. Can you see that clearly, Will?
Yes. Yep. Sure can.
Okay. So I've sort of generated this and randomized some of the information, but this commitment is from an actual commitment for an order that I generated. And just to give you some context, the way a title company gets to the point of issuing a commitment is basically we receive a purchase agreement that's been signed by all the parties from a broker and like yourself, and then we set about examining the chain of title. And once we are comfortable that we know enough about that chain of title to say to the homeowner, the seller, hey, we'll issue a policy of title insurance to you, then we issue this commitment. The commitment, as I said before, is just a promise. This is what we promise to do. We promise to issue, whether it's an owner policy or a lender policy, as you see on this first page at paragraph 2, if you do certain things. And we'll get into those certain things in the next slides. But let's start off here. This is Schedule A. This is the first part. A couple of things that Schedule A tells us. Number one, you're always going to see the street address of the property if it has one, and I've highlighted it there.
Okay.
Sometimes in rural parts of New Mexico, we don't have a real good common address or house address because it's never been developed. If that's the case, that might be blank. That field for property address may be blank.
Okay.
Then the legal description becomes more important. So the other thing on Schedule A is the date that the commitment is issued. That's important because things change. So for example, I've issued commitments and transaction hasn't closed for 6 weeks. And in that 6-week period of time, some lien gets filed by a plumber or something. And it won't get discovered until essentially a few days before closing when we do what's called a date down search. We'll search from the date of the commitment to the date of closing, essentially.
Okay.
And say, make sure that nothing else has changed in the chain of title to affect the property. So that's an important part of Schedule A.
Okay.
The other important part is what policies are going to be issued. In this hypothetical situation, the commitment is promising to issue an owner's policy and a lender's policy. The owner in this situation would be the buyer. His name's John Doe. He's a married man. He's taken title as his sole and separate property for $650,000. That's going to be the face value of his owner policy. And the bank is going to lend John Doe $600K to buy the property, and they're going to get a policy for the face value of their mortgage. Let's see here. And then the land described in paragraph 5 is going to be set forth in Exhibit A. So I'm going to go to Exhibit A, but before I do, I'll just say here, paragraph 3, the estate or interest in land described or referred to in this commitment is a fee simple. That's the most common form of ownership. But you could also have other insured estates like a contract purchaser's interest in land. For example, here in New Mexico, we do real estate contracts where owners will finance the deal. So in that situation, we wouldn't say fee simple, we would say an owner's interest under purchase agreement or a contract for deed.
Got it.
And of course, paragraph 4 just says who the current owners are.
Okay, let me ask you a quick question on the policy amount. So when this gets issued, this got issued on June 30th at $650,000. When a price change happens throughout the deal, right, in maybe 2 or 3 weeks, they adjust the price due to inspections or whatever it may be. Does that new commitment, does that policy amount get changed and a new commitment date goes in place?
Yes. If a property has a price change, then this proposed policy amount for the owner policy will change also.
Okay.
Yeah. And as for the date, typically you're either going to see that the commitment date is updated to the date of that change,
Okay.
or some title companies might just revise. They'll say it's a good, the commitment date remains the same, but it's a revision number 1.
Got it.
Okay, so going on, we're going to go to Exhibit A. Now, this is the legal description of the land, and this is really important. This is what is shown on the warranty deed to describe this particular piece of real property that's being transferred. And you always want to make sure that the legal description in your commitment is consistent with the legal description on the last deed of record, and that it's consistent with the legal description in the deed that will cause the buyer to become owner. And this is one of the most common parts of a deed that gives rise to problems because legal descriptions, sometimes there's typographical error in them. Okay. I was just doing a transaction where someone, 20 years ago was typing up a deed and they made reference to a plat recorded in the 70s. And they at that time in, back around 2020, or I'm sorry, 2000, they did a typo and they made an error in the reference to the deed. Well, that's kind of important.
Yeah.
Because if it doesn't point to or reference the plat, then you really haven't identified the land being conveyed at closing.
Yeah.
And so I'll tell you, a couple occasions I've had to do what's called a scrivener's affidavit and correct an error in that legal description.
Wow.
But you as a broker, keep your eye on that legal description.
Yeah, it seems like this would be a really quick and easy one to overlook.
Yeah, that's if there's one thing I would recommend brokers do is when you get a title commitment, you look at Exhibit A for the legal description, and you look at the copy of the last vesting deed. You should get those in every title bundle from every title company.
Okay.
Okay. Moving on. The next part of a title commitment is going to be the first part was Schedule A. This is going to be Schedule B. There are two parts. There's Part 1 and Part 2. Part 1 of Schedule B are requirements, and these are the things that, as you can see there, have to be met in order for the title company to issue a policy of title insurance after closing. And there's a lot here. I'm going to run through it as quickly as I can. But the first thing is the proposed insurer, the buyer, has to provide the name of the proposed insurer to the title company so that we can issue that policy and draft the deed correctly. So if your name is William Lambert, we want to know that that's the name on your driver's license, and so that we don't draft a deed that says and issue a policy that says, Billy Lambert.
Right.
Yeah,
it would be hard pressed to see Billy on there, but I get what you're saying. That's
yeah. or Thomas as opposed to Tom.
I would imagine
you want to make
people go by all different kinds of names, right? I mean,
exactly.
Yeah.
Exactly.
Okay.
Especially here in Santa Fe.
Especially, right? So we're looking at driver's license. Are we looking at, because that could be, I would hope it's be the same as my passport, but those are the documents you want to make sure that the deed is the same, right?
That is correct.
Okay.
Yeah. We will go with any government issued ID that we feel is sufficiently trustworthy to identify the person as the buyer. Next, we require that the parties pay the agreed amount for the property at closing. We require that the policy premiums be paid by the seller, typically, to the title insurance company. That's just natural. We're only going to issue insurance if we get paid for it. Number 4, documents satisfactory to a company that convey title, that's a deed, and create a mortgage to be insured, or both, that get executed, delivered, and recorded in the public record. So some people will sometimes come in and say, hey, I want to close and I want to record this myself. And I say no, because I got to make sure that it gets recorded. Right. Or sometimes somebody will come in and say, hey, I drafted this deed myself.
Hey,
and I'm like, no. So the document's satisfactory to the company is the key part here. If we're going to take a risk to insure title, we want to be able to drive that car and make sure it's done right.
Sure.
Number 5, I kind of skipped over. You can read that, but I'm hitting the main points here. Paragraph 6, we want to make sure that all taxes and other assessments like HOA or condo fees are paid. Paragraph 7, we want to make sure that the city, county, water, sewer, refuse, whatever, that's all paid up, because those are lienable items. Government, utility, and service providers always typically have the right to file a lien if they don't get paid for their service. And so if it's a lienable item, that's something the title company is going to pay real close attention to.
Got it.
Number 8, boundary survey or improvement location report, depending on available survey evidence and contract requirements. Pretty straightforward. We like surveys because they graphically depict what land is being conveyed. And, back 100 years ago, legal descriptions indeed would say, Mr. Williams on the north, Mr. Smith on the south, the river on the east, and the road on the west. And that's just not legally sufficient anymore.
Right. I'd love to see one of those one day.
I could show you one of those today.
Yeah, I'd love to see that.
This is a little redundant, but again, it's just, they want to make sure that association dues are paid. And then a lien waiver. This is a document that the title company has the seller sign to delete standard exception 4 that says, hey, nothing has been done that will result in a lien being placed on the property. Okay. And so let's see here. Let me get, well, I won't go into the standard exceptions right now. Let's just keep going. Requirements on this particular property in this scenario, there's 2 mortgages that the seller has. And so we're going to require that those mortgages be paid off and released.
Okay.
We're also going to require that the deed from the seller to the buyer is recorded. And then a mortgage, since he's getting a loan, also is recorded. And down here on my title commitments, I say if buyer John Doe is a married person and he's taking title as a sole and separate property, then we're going to require John Doe to join with their spouse to execute a sole and separate agreement.
Okay.
That just helps clarify who owns the property here in New Mexico, being a community property state.
Got it.
Moving on, standard exceptions 1, 2, 3, and 4 can be deleted. This is Schedule 2, B2. These are the exceptions to insurance. So, for example, if there is a known encroachment or an easement in the public record, we'll still insure the property, but we're not going to insure against potential claims arising from those known easements or encroachments. So
like a utility easement?
Yeah. So utility easement, let's say it's pre-existing. The utility easement is recorded typically either on a plat or in a separate easement agreement in the public records. And so we're gonna say, hey, buyer, you can't kick the easement holder, the utility company, off your property because A, it's pre-existing and they have a right to do that, and B, we're not going to be on the hook if you get into a fight with the utility company about that.
Got it. Okay. So that's the exception part. We're giving you title insurance, except we're not going to insure this part of it, whatever that may be.
Yes.
Okay.
There are certain standard exceptions in New Mexico. 1 through 8, as shown on this document, are the standard exceptions. I'll run through them real quick. Claims or rights of parties in possession not shown in the public records. Who could that be? A squatter.
Okay.
If there's a squatter and they've been there for a long time and you have to evict them, that's something you have to deal with as the owner. Easements or claims of easements that are not shown by the public record. As we just described, some easements are described in a plat or in an agreement and then recorded, but other easements can arise that don't get reduced to writing and aren't found in the public records. If you live in a rural area, it's possible someone walks their dog across your property. If they do that for a long enough period of time, 10 years, they can assert a claim in the court that they have a prescriptive easement, or perhaps an easement by necessity, to continue using that path to walk their dog across your property. And that's just something we don't protect against.
Okay.
because unless it shows up on a, on a plat or an improvement location report, and that does sometimes happen. We'll still take exception to it and not protect you against it, but that's the sort of easement that could arise. It's not in the public record.
Okay, makes sense.
Moving on is encroachments, overlaps, shortages in area. Again, that would be disclosed by an accurate survey or inspection of the premises. We don't insure against those things unless we just don't.
Okay.
And unless the seller executes an affidavit saying there are no such things, encroachments, overlaps, whatever, on the property. So that's that affidavit that you saw in the requirements section, and there's a similar, the same affidavit has language in it to release standard exception 4. This is we won't insure against material liens or mechanics liens. Like, for example, a seller has a roof put on 2 days before closing to satisfy a buyer, and then they just decide not to pay for it. Under New Mexico law, that roofer can put a lien on the property. Now, what do we do to protect against that? We get the seller at closing to sign an affidavit saying, we promise we've paid for all work done to the property, and then we can delete those.
Okay.
And on my website, I've got a slightly more in-depth explanation of how standard exceptions 1 through 4 are deleted so as to expand coverage under the policy.
Awesome. We definitely need to check that out, because I know that this is a key area here, especially in our area.
It sure is.
Where can we go to check that out?
www.paramounttitle, NM as in New Mexico.com.
Okay.
And if you go under the first drop down, title insurance, it'll be in there. Should I delete title exceptions 1 through 4?
Sure. I'll make sure I get a link in this too to be able to click on and go to. So that's perfect.
Okay. Moving on, standard exception 5. This just deals with, again, community property or homestead rights. We won't insure against those unless we delete this, and we will delete the standard exception if the buyer or seller, I should say the seller, I'm sorry, is an entity. So an entity is not married, so it's not going to have community property survivorship or homestead rights out there. So if the seller is an entity, we'll delete that. 6 is water rights or claims to title to water. As you know, we live in a state where water is scarce, and we don't insure water rights. We only insure the dirt. So water rights is a totally separate issue, which I'm sure you and your brokers deal with on a regular basis.
Absolutely.
Taxes, we don't insure against taxes that become due and payable after the closing. Okay, we only insure that at closing all taxes are paid, or that the buyer and seller have received an accurate proration so that the buyer can pay them later in the year.
Okay.
And then finally, this is an exception you'll only see in a commitment. It says, we're not going to insure against defects, liens, encumbrances, or adverse claims of others, if any, created and first appearing in the public records or attaching to the land subsequent to the effective date, but prior to the date of the proposed insured inquires for value. So that's between the time the commitment is issued and closing. So this is basically, it's called the gap provision. It's a gap between when that commitment is issued. That's why that commitment issue date is important, and the closing.
Yep.
However, it's our job as a title company to do that date down search and make sure that there are no encumbrances or liens that have encumbered the property since the commitment. So in the policy, we'll delete this. We won't take exception to this because really that's our job. We're just saying in paragraph 8, hey, there's stuff that might come up between the date of the commitment and the date it closes, and we'll take care of it.
Okay.
Okay. Moving on. Again, this is a bit redundant, but it's in here and it's common. Assessments by local authorities for sewer, garbage, not yet due. Number 10, we don't ensure that the property is in compliance with state or county subdivision or zoning regulations or local ordinances. If a perfect example of number 10 is someone is buying a residential property and moves in and then decides they want to run a business out of the house, and the county zoning authorities knock on the door the day after closing and say, hey, you can't do that here. And then by taking exception to the coverage here, we're saying, hey, you know, we're not going to defend you against the violation of the zoning regs. Does that make sense?
Yeah, absolutely. Absolutely.
Yeah.
There would be too many things you could be on the hook for there. Way too many things.
Right. Paragraph 11, again, I stick this in here in my commitments just because acequias are a thing here in New Mexico. It's basically saying we're not going to insure against basically arroyos, acequias, anything that could hold water or be considered to be navigable in some way. And the definition of what is navigable changes somewhat under case law from time to time. We just had a case decided by the New Mexico Supreme Court here in New Mexico that dealt with whether hunters and fishermen could access land or access hunting or fishing areas by walking essentially or traveling in a boat on these waterways. The decision, I won't get into the decision, but the decision basically kind of changed the law here in New Mexico. And so we put in this exception just to say we're not going to get involved with disputes between the new owners and, you know, hunters or somebody in the future about, you know.
Well, now I'm really curious. You know, can I walk up the middle of the river to get to my favorite fishing hole?
Well,
I'm going to have to read
I'll send you the decision.
Okay.
And I posted about it on Facebook a couple of times.
I do remember that.
Yeah, and so you know, it changes from time to time. I don't know. Did the sharing screen change in any way, Will?
Yeah, now it's back.
Now it's back. Okay.
Yeah, it went into your email. So
yeah, I'm sorry.
Get to see what you're working on.
Yeah. Let's see here. Number 12. We only insure the surface estate. We don't insure the subsurface estate here in New Mexico. There's a lot of oil and gas. There's a lot of you know, there used to be mining activities around Santa Fe County. So we're not going to insure, you know, that you have the right to own. We're not going to insure your title to the subsurface estate, whether it's oil, gas, you know, sand, gravel, whatever.
Okay.
We don't do that. 13 is, again, here in New Mexico, a lot of the land was patented. And so there are frequently reservations in those patents saying, you know, the patentee had to use the land, but subject to these certain use restrictions. Those restrictions are from the federal government primarily. Sometimes they're from the state of New Mexico's government. It's a state patent, but they don't go away. So we take exception of those. Again, this is a New Mexico specific thing. Ditch rights, water rights pertinent to the insured property. Again, water rights are governed by the Office of the State Engineer. And under the system of laws we have in New Mexico, they're not subject to being insured like a surface estate in land.
Okay.
Now, this is where, in this particular commitment, paragraphs 15 through 20, these are all covenants and patents and restrictions. You see, paragraph 15 says patent from the US recorded 1931. Here's another patent recorded in 1936. They have restrictions in them, so we take exception to them. There's other restrictions that are called specific exceptions because they're unique to the specific property. This property was located in the Tierra Contenta subdivision, so it's subject to the restrictive covenants and design standards for that subdivision. So those are just what we'll call specific exceptions to coverage, because we're not going to pay the legal bills for a homeowner in the future to fight the homeowners association.
Right. Right.
Paragraphs 21 and 22 these are easements. These are specific easement agreements, and we're not going to help the owner in the future fight an easement that has been around and recorded in the public records since, in 20 years ago. And finally, we're also going to take exception to whatever notes or easements or conditions are shown on a plat. So going back to, remember when I said you as a broker want to always check and make sure that the legal description in Schedule A matches all the deeds. You might also want to take a look at the plat. I recommend you look at the plat.
Okay.
The clients look at the plat, because that's going to show graphically where the land is, what its shape is, what surrounds it, whether there's access. And so we take exception to the plats. Essentially, we say if the plat has an easement, we're not going to help the owner fight that easement. Okay.
Yep. Got it.
And just this is the end of it. Really, this is the end of the title commitment. So I would just say here are some email or URLs, I should say, to other organizations: the Consumer Finance Protection Bureau, American Land Title Association's home closing portal, New Mexico Land Title Association. Of course, Paramount Title has a lot of resources that could be helpful to buyers and brokers alike to understand title commitment issues.
Well, awesome. I'll make sure that I get these links on online as well, and be able to share this information. It's been quite informative, and I know already what I need to do to better myself when I look at these title commitments. So this has been fantastic, Tom. I really appreciate it.
Great. Well, I'm glad you found it useful, and it was a pleasure meeting with you today. And if I can be of service to you or your team, just give me a call, okay?
Hey, sounds good, buddy.